singular pleasure for me to introduce to you Ken Anderson, who is a long-time collaborator with Telos, though not recently, but we hope more in the future. He is currently a law professor at Stanford University in Washington, D.C., where he teaches international law, including the law of armed conflict. He also serves as the book review editor of the national security law website Lawfare, and writes on national security, armed conflict, counterterrorism, and weapons such as armed drones. His most recent work has been on advanced automated and autonomous weapons, and his most recent book, co-written with Benjamin Vittes, is Speaking the Law, the Obama administration's addresses on national security law from 2015. His paper today is entitled Situating Asymmetrical Warfare Among Forms of Emerging Conflict in the Post-New World Order World. Please welcome Professor Anderson.
I am hitting the start button here. So, thank you, David, for that lovely introduction. And I have to say that the paper title is no longer exactly accurate for what it is that I'm going to talk about today, largely because Stephen Metz's splendid presentation yesterday said an enormous amount of that which I would have said, and said it much better than I did. I mean, I thought that was really an extraordinary presentation yesterday, and I sat with my remarks prepared and ticked off the things that I was going to X out. So I did a fair amount of hasty reworking yesterday, and essentially would like to pick up where Steve left off in a certain way, and also to expand a sort of parallel story that I think goes to an enormously important element of asymmetrical or asymmetric warfare that the Telos conference, this Telos conference, has very properly focused in on, which is the question raised by Max Boot in the kind of working definition, I guess, that we apply to asymmetric warfare here, of politics, press, propaganda as being elements of ways in which a weaker, materially weaker, militarily weaker adversary looks to wind up making up that weakness against a stronger adversary. And to that, what I would like to add then is beyond the three Ps, so to speak, and in some sense is a subset of politics, but in another sense its own sort of category, is the question of legitimacy. The question of legitimacy, in particular, expressed through law, both domestic law, and we'll focus on the United States in this case, and also international law across a range of subjects, but most importantly for these purposes around the law of war. Legitimacy and law are, I think, essential elements in understanding asymmetric warfare, and they wind up sharing an important characteristic with these other politics, press, propaganda, but propaganda is a pretty loaded term in the English language, and we could think of that more broadly as press narratives and narratives, but also debate, right? I mean, people having legitimately different points of view about a lot of contested issues and how one's supposed to approach terrorism, counterterrorism, conflicts of various kinds. And this then raises what I think is going to be one of the most difficult aspects of addressing legitimacy in law and these other elements of politics, which is that in one sense we want to talk about them instrumentally as tools that are deployed by one side against another side, by the weaker side against the materially stronger side, and the other way around as well. And in that regard, then we think of them in instrumental terms. What are they going to do to advance my cause of victory, so to speak, to get where it is that I want to wind up at? And yet, the tools that we're talking about also have a life of their own, in which we think that different points of view are entirely legitimate. So to give an example from the sort of lawfare category, lawfare, as Bo, where is Bo? Yes, said yesterday in your discussion of lawfare, involves essentially the use of law, legal criteria to essentially try and constrain somebody, or to use law as a way of finding permissions to engage in something that would not normally be considered as kind of part of the military struggle, so to speak. One avenue for this might be the filing of a lawsuit, and Bo raised examples that essentially involve empowering private citizens to sue foreign governments for their alleged complicity in various terrorist actions. Most particularly at this moment, the JASTA legislation that would allow families, victims of 9/11 and so on, to sue the Saudi government and potentially its businesses and worldwide, and particularly stuff in the United States, in federal court, and look for tort recovery for these things. Lawfare in the sense that this can have tremendous ramifications in many, many different directions, but is not part of a battlefield strategy, certainly, and is not even one that is aimed at directly the terrorist group that one's actually worried about. It's sort of very indirect. But there are more direct examples of lawfare being used in ways that raise this problem of legitimate politics, legitimate debates over law, legitimate debates over the question of what should the rules, so to speak, actually be, and what creates legitimacy. So, for example, when the ACLU files suit in some case saying it is not okay to target an American citizen in Yemen, despite what it is that you've said, and the whole sort of series of criteria stating that you're depriving Anwar al-Awlaki of due process, and et cetera, et cetera, et cetera. In one sense, if you were looking at that purely instrumentally, and you were starting from the assumption that Anwar al-Awlaki should be dead, then the lawsuit is merely a sort of instrumental tactic in which you were attempting to sort of constrain your enemy. If you're the ACLU, it's filed it in perfectly good faith, believing that this is actually a violation of the rules. So the difficulty that arises, particularly with regards to law as a sort of expression of legitimacy, but it's also true of press narratives, it's true of politics in general. It's the problem of, is it actually possible to distinguish between that which you regard as engaged in good faith by people that think that this is actually the way things should go, or this is the way the rules of the conflict should be interpreted or structured, versus people that are simply, they already know what they think, and in some sense we regard their goals as being outside of the legitimate, because they would like to have a set of rules that would make it as easy as possible to introduce a suicide bomber into the crowded market, et cetera, et cetera, et cetera. The problem is, the action may be exactly the same in the sense of going into court and asking the court to rule that your civil liberties to go into the following place without being searched by X-ray machine and so on. That's actually a legitimate thing that people are able to do, and it's sort of irrespective of how terrorist groups may wind up manipulating or using that. So that's the ambiguity that's associated with an awful lot of the stuff that we regard as symbolic in some fashion, but nonetheless has tremendous possibilities, at least, of consequences, because these things like the use of the press, the use of social media, the use of the law directly wind up having enormous ripple effects on the way in which our conception of what's okay and not okay is structured. So that is at the heart, I think, of what this Telos conference has looked to get at beyond the sort of narrowly strategic battlefield military, right? Beyond the sort of narrow stuff that takes place in asymmetric conflict in particular battlefield. So the classic case of asymmetric conflict involves the use of human shields, the use of civilians, commingling with civilians in ways that violate the laws of war. And the response of the adversary on the other side is to say, what do I care? Right? And the problem for asymmetric warfare is going to be for an adversary that is in some fashion militarily stronger in any material conventional sense, but at the same time, and this is part of the asymmetry that I think needs to be stressed, and which, again, I think the Max Boot definition that is serving as the sort of source for this conference gets at. Part of the asymmetry is not merely the material differences between the two sides. It's the sense in which you are constrained in some fashion by norms, by morality, by law, and by the need to have a legitimacy that in some fashion is grounded in those things. Now, that's what primarily concerns me here, and I think that it picks up essentially on a lot of places where Steve left off, because it goes to this sort of directly to law certainly, but in a sort of broader fashion to the legitimacy question. Okay, and I'm not able to read my handwriting any better with my glasses on. So, with that as kind of the background, I want to proceed in the following order. So I want to say a little bit more about what I think legitimacy means and how law winds up fitting into that. And it's not going to be any kind of high telos theory. David, when I moved to Washington and started engaging in a lot more sort of directly policy stuff rather than telos stuff, it's like the center in the brain burned out. Right? So we're going to see whether I can re-engage the neurons over the next while that re-engage with sort of telos style theory. But whatever I say about legitimacy, I don't mean anything theoretically laden by it at all. Okay? Nonetheless, we do have to say something about the relationship between law and legitimacy. Beyond that, then I want to do something in a sense even simpler, which is I want to have everybody huddle around the campfire, so to speak, and tell you a story. And the story will be essentially an account of the changing ebbs and flows of law and legitimacy, at least as far as the U.S. government is concerned, beginning 9/11, coming up to the present. And kind of phases within that I'll arbitrarily delineate as kind of the first Bush term, the second Bush term, the first Obama term, the second Obama term, and then something into the future. And then we'll wind up attempting to kind of look into the future a little bit, but not very far. And the discussion is about asymmetric war. A lot of what I'm describing is really asymmetric war in the context of U.S. counterterrorism policy following 9/11. So not so much on the war in Iraq, war in Afghanistan, except that it sort of bears on that, but it's really far more on what I think is the most contested issue, which is the question of the contours of what legitimate counterterrorism looks like against a transnational non-state actor. So I'll draw some conclusions and speculate about where I think this is going towards the end. But let me say then, first of all, just a couple things about Okay, if the clock turns off, that means that none of that time counted. Okay, you got your clock. I'm going to put this over here. Nice try. So let's say a little bit about legitimacy and a little bit about law. And by legitimacy, I just mean a sort of very simple, theoretically unladen idea that legitimacy within a political order, within a legal order, resides in the fact that you have people, individuals that have internalized not only a habit of obedience in some behavioral sense to commands from authority, or the rules that sort of structure the political community or the social community and the legal community, but they, broadly speaking, accept those rules as being right, as being correct, and that the obedience to them is not simply the observation. It's not like Hume watching one ball move up to the other billiard ball and saying, I don't see any cause there. It isn't behavioral in that way. It's looking and accepting the idea that there is actually an internalized psychological sense that this is right. Now, that's just Weber all over again. And of course, it doesn't mean that the structure is right. It doesn't mean that the rules are, in fact, morally correct or anything like that. But it does say that there is this sort of investment in the idea that these things are right and that they represent some form of authority. And in political areas, and I guess I'd say especially in the realm of kind of international law, international institutions, nation states, and all the rest, and they're dealing with one another, authority is probably most easily thought of as being power conjoined with legitimacy. So in other words, authority is the legitimate exercise of power in some fashion internalized and acknowledged by the parties with respect to whom one is exercising it. And we'll come back to that in relation to the U.S.'s role in the world. And the other striking feature, I guess to say, about legitimacy is that legitimacy by and large attaches to institutions. So in other words, legitimacy involves individual transactions, but the internalized sense is not one that necessarily, and in fact, none of us think this way, that every command of legitimate government is in fact legitimate. It doesn't proceed on a sort of all or nothing basis of every single transaction. It's rather something that attaches to the institution and the sum total of its transactions and its dealings with the people over whom it has authority. And that leads to a couple things. One is that there can be commands of the sovereign, so to speak, that you don't make any sense, but following them because you think that it's an important sort of expression of a rule of law as expressed institutionally, even if you think this one is wrong, idiotic, irrelevant. And there are limits to that. I mean, some of the limits are cultural. Classic joke of, in what societies do you wind up pulling up to the four-way stop in the middle of rural Nevada, right? And looking and seeing nothing in any direction, you don't actually, you just go through the stop sign or you run through the red light or whatever. And at the level of that transaction, obviously you can run that red light, so to speak, without challenging the sort of legitimacy of the traffic laws and the authority that has them. So it's institutional in a sense, and it doesn't have to attach to any particular transaction in which there is an exercise of authority. The institutional sense winds up being critical, again, for our purposes in relation to terrorism, counterterrorism, responding to it, and the problem of asymmetry. Because it's to the institutions that we look to make the responses. And the institutions are institutions that wield great power, great material, military, other kinds of power. And the legitimacy of the actions that they undertake is going to be of enormous importance in kind of structuring how we wind up seeing, right? And again, going back to that extremely useful list that Steve gave us yesterday about forms of asymmetry, asymmetry of the will, asymmetry of patience, asymmetry of legitimacy, right? I mean, these various forms of asymmetry. Institutions and that legitimacy is going to have a huge effect on your sort of staying power, so to speak, in the fight. Now, it doesn't have to be political. In other words, it can be religious. One of the things that I think is most striking about, I guess I would say, many of the people that I work with on a policy basis on areas related to terrorism, counterterrorism, security, particularly the people that are in the civilians who are in various positions where they've come out of the most elite institutions, and perhaps, Russ, this has some bearing on our discussion later on about the universities. What I find really startling about many of these people is that it is simply viscerally impossible for them to grasp that religion can have any kind of transcendental power, because they haven't been raised religiously. They've never had any kind of religious experience in any kind of internalized way in which it is legitimate and in which there is genuine meaning to the commands of God and legitimate meaning attached to the people with whom you have invested the idea that these are God's representatives on earth. And so they're sort of trapped in a kind of rational choice, rat maze, unable to understand that there are sources of legitimacy and motivation, and that, I mean, it just, very frustrating discussions, because you want to say, for this the saints hang in the fires, accepted martyrdom, all of these things, how can you possibly ignore this as being a profound source of engagement, legitimacy, all of these other things? And that's what your adversary is banking on in a certain way. So the notion of legitimacy then is tied up with institutions, but institutions in our sense are always institutions that are bound up with law. So legitimacy is tied to the rule of law. Law is tied to the rule of law because it's expressed institutionally over time in repeated transactions around the law with particular people, individuals, groups, all of that stuff. And the expression of legitimacy becomes essentially a way of institutionalizing and expressing a collective will. Again, very hard, I think, for my many friends who are entirely trapped within a kind of narrowly economics paradigm about rational choice. It's impossible for them to think in terms of a group as being more than simply its individual members pooled together. In my day job, I teach corporate law. The essence of corporate law is that the corporation is irreducibly social. And it's not, in corporate law, we distinguish between a partnership, which is a collective of the shared partners sharing their individual powers. The corporation we define to be an artificial entity, a group that is not just a group, but a group which has a corporate identity as a group that's irreducible and not simply the sort of aggregation. In corporate law, we distinguish between the aggregation and entity theory of group agency. That winds up also being a weirdly intellectual hurdle for numbers of people analyzing policy in these areas to sort of overcome. It's just the kind of summed preferences of individuals, and the inability of that to capture religion and to capture religious commitment, I think, is just enormously damaging in terms of the kind of analysis. And I fault the universities in large part for that. Russ, I'm going to keep sort of running total here of all the places in which I fault the universities for sort of failures to be able to engage with the, and I'm looking at Russ because of the later discussion we're having.
We'll send you a tuition.
Yes, absolutely, yep. Now, that sense of legitimacy tied up with law has a domestic law aspect in the United States because it ties up with the entire structure of constitutional law. It ties up with all of the other laws that we have. The panoply of laws touching on terrorism, counterterrorism, all of this stuff runs across everything. There is nothing that is not touched by this, including every financial transaction, anything involving the banking system, the movement of money. All of those things in some way are have legislation that winds up adhering to them. Now, the question, however, about legitimacy, specifically in relation to responding to terrorism, counterterrorism and law, becomes important because we ask what, of course legitimacy matters, of course law matters, of course institutions matter. This is not really very interesting. What is it that in some sense you're trying to tell us would be the other alternative that you're implicitly arguing against? And that is essentially necessity. The argument that necessity trumps everything else. In time of war, law is silent. And that legitimacy reduces down in the moment of emergency, in the moment of crisis, down to simply the necessities of the moment, and you simply proceed in sort of serial order to deal with the emergency that's out there. And that necessity is its own justification. Now, that is actually very often imagined as being the nature of how countries respond to any of these sorts of emergencies. And it's certainly true that there is some moment in time where necessity is the sort of dominant thing because it is a transaction at that moment. What I want to turn to in just 1 second is essentially to fill in the gap of how quickly that turned following 9/11 into a question of law and legitimacy in the broader institutional sense, and stop being governed by just kind of justifications and demands of necessity alone. But the striking part about this is how much of the literature winds up assuming that the responses of states, the responses particularly of large democratic states with many multiple interests that are mediated by law and by various institutionalized political structures, how quickly law reasserts itself in those cases. And maybe they're bad laws, maybe they are unjust laws, maybe they are laws that are simply on the surface recapitulating necessitarian logic. But I want to suggest that that's not the case past a fairly short period in which the crisis is the transaction. And before sort of turning to this story and to this narrative about 9/11 going forward and the response to counterterrorism, I'd say that if legitimacy is tied to institutions and the repeated actions of institutions over time, necessity is very much transactional. It's in the moment, right? It's in the immediate crisis that's sitting in front of you. And it's responding on sort of a, this is what's happening now, necessity demands that we do this. And generally speaking, it's a way of overriding what are the sort of longer term structures of law. And this, my suggestion would be very much that the experience of the United States past 9/11 is that legitimacy is what's required for any kind of long-term effort that has to come through longer-run structures of law, and that the appeal to necessity is going to last only a relatively short time. So, enough about the nature of law and legitimacy. And I guess the one final thing I'd say about that in relation to asymmetric warfare is so much of what the terrorism, counterterrorism struggle has been about is related to how long you're willing to hang in there. So in other words, you have terrorist groups that have a sort of internalized religious view of things, and they're willing to hang in for eternity, right? Or at least that's kind of their announced time frame. If you have the responding democratic state, the United States, other places, the response has to be two different senses of time. One is it has to be temporal in the sense that we aren't looking for sort of eternal life in all of this. We're looking for some kind of time frame which is long enough to be institutional and out of the sort of directly in the moment. But the ability to prevail, again going back to what Steve said yesterday, or at least to prevail in what you define to be your aims, even if that's just management of the conflict going forward, management of groups that intend to do violence going forward. Even that requires a longer term focus in which structures of law at the institutional level are going to wind up being vastly more important over the long term than necessitarian logic at the moment. Okay, so against that as time, persistence, willpower as being core elements in the sort of ways in which asymmetric struggle is waged on each side. Let's now turn and give a fairly simple accounting of what happens past 9/11 with regards to law and legitimacy in the United States. So there was a necessitarian moment, very clearly, and was it unlawful? Was it outside the law? Was it extra legal? Not within the U.S.'s understanding of those terms, meaning by that in the hours and days following 9/11, the Constitution, at least interpreted by the Supreme Court for its entire history, constitutional structure in terms of the nature of the executive, grant vast powers to the president. And it was not a surprise that the examples that were reached to in that sort of necessitarian moment essentially went back to Lincoln. But even in the moment in which there was essentially the most draconian measures being imposed in the most sort of obvious logic of necessity, into a moment of uncertainty when you don't know where the next plot may be coming from, you don't know whether this is linked to other things, you don't know whether there's something that's sort of imminently on the horizon, and you have no idea who it is that you're looking to pick up in order to get answers to any of that stuff. Even at that moment, the language is all within sort of the structure of constitutionally granted powers, emergency powers of the president. And the appeal to Lincoln is very deliberate because Lincoln was enormously concerned that he at least justify his acts, even his most radical things that departed from accepted constitutional norms and customs and the rest, that he framed that in some way in relation to the existing body of law, at least as a matter of post hoc justification. Now, post hoc justification using the language of law gets a very bad rap. You're just invoking this and this and this to justify what you're planning on doing anyway because you thought it was necessary to do it, so you're just trying to come up with a rationale after the fact. In one sense, that critique is clearly right. In another sense, it nonetheless is constraining language. The way in which you wind up offering post hoc justifications or before the fact justifications, the fact that you're appealing to law and that you're appealing to institutional and existing structures of law winds up meaning that in some way you're looking to legitimacy as a framework in a larger sense. It may not, in fact, justify what it is you're doing in sort of objective fact. It may be that down the road people look at it and say, this was just an abuse of power dressed up in a certain kind of language. So maybe difficult to sort of anticipate how it will be seen in terms of its legitimacy down the road. But against the idea of sort of pure necessity, it's hard to find, not just in the United States, but even if you look to the Melian dialogue, the generals are justifying themselves, and they're justifying themselves by reference to custom and law, and they use necessity and all the rest, but in fact there's a much richer language that's going on with that. Specifically one that has, I think, an enormous amount of purchase in many of the conflicts, especially the civil wars that go on today. The necessitarian language used by the Athenian generals in the Melian dialogue winds up, in one sense, just saying we had to kill them, otherwise bad things are going to happen down the road. But it wasn't merely an argument from prudence. It was an argument from the prudence of killing these people because we have to protect our children and the future generations. This is a language of moral justification, and it's a language that winds up justifying pretty much whatever you want in terms of that, but it is a language that is more than just sort of saying this is the nature of necessity or a necessity of nature, and that, I think, winds up giving a sense of the enormous importance of legitimating language where there is a sort of buy-in into what it means, at least by the political community that one is involved with. And maybe a better example would be on at least two occasions, I can remember, over the time that I spent as a human rights monitor, essentially going around for Human Rights Watch to various wars and conflicts in the 80s and 90s. I remember particularly two conversations with two warlord militia leaders. One of them was in the Georgia-Abkhazia thing back in the early 90s. And the militia leader was engaged in hardcore, brutal, murderous ethnic cleansing. And I said, why are you doing this? And he said, why don't you strike some kind of agreement with these folks and go back to sort of your peaceful ways? And his response to me was, in one sense, sort of the pure necessity argument of the Melian dialogue. I have to do it because otherwise they will, I can't risk that they'll come in and do this to us. But his answer was more complicated than that. He said, Mr. Anderson, if it were just me, I would wind up being willing to take the risks in order to essentially strike a peace with these people. I would even be willing to risk my family. But I've been invested as a political leader responsible for the safety of my people, a whole lot of people, and my corporate law, the antenna on the back of my head, that's what I'm rubbing back here, perk up and say, he's offering me the language of a fiduciary who feels compelled to act on behalf of others and essentially to look out for their best interests, right? The duty of care and the duty of loyalty, as we call it in corporate law. And that's what he was appealing to, right? He was in effect saying, if it were just me taking the risk, I would do it. Even if it were just, my family, but I cannot take those kinds of risks on behalf of the people that have entrusted me, right, with their safety. And that's a very different and vastly more motivating concept because it appeals to a sense of legitimacy, a sense of duty, a sense of purpose outside oneself, and the sort of narrow self-interest, narrow necessity. And those are the kinds of motivations that I think really are what are at issue on kind of many sides of civil wars and in many of the conflicts that are going on. Especially if one accepts that in the radicalization process, you wind up, in religious radicalization, you wind up taking on the sense that you are acting for other people. You are a fiduciary on their behalf. You may have to die on their behalf. And of course, it's what soldiers wind up internalizing as well. They are willing to go out and die on behalf of a community that may or may not appreciate them. Okay, so 9/11 takes place, and there is this sort of brief moment of necessitarian stuff, but even that winds up having a lot of justificatory language in law that will matter because the justifications in law that are offered are going to be, in many senses, that which is interrogated afterwards to see whether they think they got it right or not, whether they exercise power in draconian ways in the face of the emergency, in ways that comport with our sort of broader legitimacy understandings from an institutional standpoint. Now, the Bush 1 administration, meaning the first Bush term, winds up adopting very quickly legal language, but the legal language that it adopts is language that, first of all, is very much at odds with how the leading parts of the legal community around the laws of war within the United States and within the United States government see it. So, in other words, the first assertion made by the White House is that the perpetrators are terrorists and they'll be treated as terrorists, and when we go after them in Afghanistan, it won't actually be a war. That was the initial position taken by Alberto Gonzales, White House counsel, and the laws of war will not apply. And the U.S. military said back, by law, we never fight except under the laws of hostilities found in the international law of war. We don't fight otherwise. We have to do that. We're constrained by both international law and by U.S. laws and everything else. White House very rapidly sort of changes its tune on that. But the focus of the first Bush administration in terms of legitimacy issues related to Al-Qaeda taking the fight to Al-Qaeda by going to remove its safe haven in Afghanistan, then sort of, let me leave aside the Iraq War for the moment. Hard to see that as a safe haven, but the sort of obvious war going to Afghanistan to go after the people that did this and to take down their safe haven, that's a war. The question that arises, however, is going to be the legal status of the people that you wind up capturing in the process of that war. Are they to be considered POWs under the Third Geneva Convention, or are they not? The U.S. government took a position from which it is not varied today, which has been approved by the U.S. Supreme Court, which is broadly accepted by our allies in Afghanistan, which is that people who are part of Al-Qaeda are unprivileged belligerents. So they're not entitled to POW status. They are entitled to sort of a bare minimum of humanitarian protections under the law of war, but they're not entitled to POW status in kind of a full, in a way in which you see it in all those World War II movies. And that becomes sort of frozen in place. It also winds up becoming frozen in place at Guantanamo, which after all is a military administered facility. The Supreme Court has blessed a theory that says that the detainees there are held in detention and can be held without charges and can be held not indefinitely, but pending the end of hostilities under the law of war, which looks to be a long way off. So that's the sort of legal theory that's operating there, and the issue that winds up arising for that is largely about detention, treatment of people in detention, harsh interrogations, waterboarding, all these kinds of things, and the legitimacy questions that arise out of that wind up being the legitimacy questions around those practices and around detention. At the same time, other states and leading organizations that deal with the legal aspects of this stuff, principally the International Committee of the Red Cross, the ICRC, are expressing grave concern with the legal conceptualization of the Bush administration's global war on terror. And the reason it raises enormous concerns to them is because the assertion by the first Bush administration is that it's a global war, and in any operation or business conducted in relation to that war, the laws of war apply. Doesn't matter where it is. Now, the legal basis for that is actually pretty straightforward. War follows the fighting and follows the combatants. And if you go to some neutral place, you may violate the law of Belgium when they come into Belgium, and I'm thinking of World War II and World War I and all the times that Belgium has been invaded in violation of its neutrality. It may be a violation of its neutrality, and there may be legal problems with that, but the actual conduct of hostilities on Belgian soil by armies violating its neutrality remains governed by the law of war, the law of armed conflict. The ICRC was, I think, the most vocal in being alarmed, but certainly all of America's allies were. And the reason was that it essentially asserted that any time the Bush administration, any time the US government wanted to pick up somebody, hold them, detain them, interrogate them, it would see itself as entitled to apply the law of war rather than the sort of human rights law or the domestic law of the place involved. And that struck, I think, nearly everybody as way too broad. Now, the Obama administration rolled that back, and in fact, the second Bush administration rolled that back into a very different legal conception, but the legitimacy issues were completely on the table at that point with regards to how far do you see this war going, and it remains one of the most live issues today as to whether there is a so-called legal geography of war defined in international law that confines the application of the law of war to particular places, hot battlefields, things like that. The problem with the Bush administration's position from a legitimacy standpoint was that it never actually had any intention of waging war in most of the vast majority of the places in which it said that it could assert the laws of war. In effect, what it wanted was the ability to use the laws of war wherever it went without actually fighting. And the position that the Department of Defense, the Obama administration has backed off to is the laws of war will apply where you actually conduct hostilities, not simply where you pick up somebody and interrogate them. So in other words, the sort of problem of the first Bush administration was that it put the cart of law ahead of the horse of hostilities. It wanted all the legal advantages of being able to use the law of war to set aside ordinary domestic law. But it didn't actually have any intention of conducting hostilities or fighting or engaging in any shooting or anything like that. Okay, so now we wind up moving forward into the second Bush administration, and here the source of legitimacy becomes much less, detention, Guantanamo, all that stuff is still on the table, but at least within the United States, the Supreme Court decisions in Boumediene and sort of other decisions about Guantanamo detainees essentially sort of fix the contours of what within the United States at least is considered legitimate, although not in very large parts of the rest of the world. But in the second Bush administration, as the wars in Afghanistan and Iraq are underway, while at the same time there is the question of going after al-Qaeda operatives and terrorists and so on in various other places, drone warfare begins to assume much more importance. And that then winds up shifting the controversy over legitimacy and law and what's lawful and where can you use the law of war and things like that into the heart of what hostilities and the law of war is all about, which is not actually detention or prisoners of war, but actually about targeting. The conduct of hostilities is the conduct of targeting. And so the question is, where can you use the laws of targeting and the laws of war, and when are you, so to speak, outside of anything that can be considered kind of the conduct of warfare? And that becomes the new question that kind of dominates the legitimacy arguments in the second Bush administration, but even more significantly into the Obama administration. So let me sort of switch to 2009. And from the standpoint of just sort of military affairs, there are 1,000 reasons why drones are an incredibly useful thing, primarily as a surveillance tool or kind of original technological development. The limitations on drones, Steve alluded to yesterday. The current generations of drones that we've got are basically vulnerable to any air defense system. These things are useful against non-state actors on the ground somewhere where you're able and looking to keep sort of watch over them. From a strategic standpoint, the problem of the U.S. insofar as it's attempting to engage in counterterrorism is it has to get to its adversaries. And its adversaries are out somewhere in some safe haven called Afghanistan, and they're also dispersing into other places, tribal zones, Pakistan, and further abroad. And as they wind up enabling and helping to set up sort of parallel organizations, sympathetic organizations, AQAP, the sort of branch in Yemen, Mali, various other places, they're sort of inspiring similar movements and folks that are, in some cases, declaring themselves part of this thing, and in other cases not. And it's an enormous problem for the lawyers and the kind of liberal democracies to figure out how to characterize membership from the standpoint of targeting. When are you part of the hostile forces of the enemy that can be targeted with lethal force as such? Right? Nobody carries a membership card. What are you going to do in order to sort of decide? Well, curiously, they do carry membership cards in some cases. In documents that were captured in the cave operations early on in the war, which eventually were declassified and released, Al-Qaeda had actually set up what amounted to a sort of retirement pension plan for its fighters. That is a level of internal organization that dealt with matters that would be intensely important to fighters who were in it for the long term, because they marry, right? They have children. They're looking for them, if they become a suicide bomber, to be provided for. And this winds up getting written down because it's a law-based system as well, and the sort of legitimacy of that and the belief that these things will happen turn out to be enormously important. So the targeting questions become the center of this for the early Obama administration, and for a couple of reasons. One is that the Obama administration has looked and said coming in, our goal is to end America's wars, and specifically 3 of them: engagement in Afghanistan, engagement in Iraq, and the fighting with Al-Qaeda. Now, leaving aside Iraq and Afghanistan, from an asymmetric conflict standpoint, Iraq and Afghanistan present a tremendous problem of asymmetrical tactics on the battlefield, all of it involving the use of civilians, all of that use of civilians illegal under the laws of war, all of it entirely ignored by the adversary on the other side. And leaving aside all the other reasons that drones and things like that are useful for lots of reasons, the laws of war are actually very, very filled with provisions that deal with the lack of reciprocal observance of the obligations of the laws of war and what happens. So, in a concrete example, if you have a protected place, a hospital, for example, or a mosque, or a religious institution of some kind, it is protected, unless the enemy decides to use it as a sort of place from which to engage in hostilities. And there's a specific provision that says that you are required to respect its sanctuary status until you have sent them some kind of message indicating that you are going to start targeting it unless they quit using it in violation of the laws of war. So, in other words, one way, and historically the way of enforcing the law of war was a sort of self-help provision that was said if they're not observing it, then you are allowed to, in this case, attack it. It doesn't remain privileged. Now, we have a special rule that says you have to advise them that they are doing this in violation of law. But once that's done, then you're free to go ahead and attack it. The U.S. made a decision clear back in Desert Storm that it was never going to do that. Not as a matter of interpretation of law, but as a matter of policy, believing that that would actually be a bad thing. It ignored the fact that in any of the wars in the Middle East, neither side had ever paid any attention to any of that stuff and never considered things like hospitals, religious places of worship, things like that, to be of any importance. But this did not go unnoticed, of course, by the adversary that then took an understanding of what not the U.S. understanding of law was, but the U.S. understanding of the rules, of its own rules of engagement in order to say these things are off limits, hooray. Right? The problem of civilians being used intermingled is in many respects more difficult because it's not unlawful to attack a combatant who's in the midst of civilians, whether they've been put there intentionally or not intentionally. But in order to do so, you're going to have to engage in some kind of calculation or some kind of assessment of the proportional harm that you're going to do to those civilians you anticipate in relation to the military benefits of engaging. And again, if you know what the stronger adversaries' sort of tipping points are in terms of confronting that enemy, then you're going to be in a position to sort of calculate very exactly how many people you have to surround yourself with in order to render yourself off target. So you have, in the case of some Taliban leaders who figured correctly that they were being targeted with drone strikes, in some cases strapping a baby on the back and carrying it around in a backpack anytime you went outside in order to sort of forestall an attack, which might have been legitimate, might not have been legitimate under sort of proportionality rules. But what matters from the standpoint of, so to speak, gaming the system, I suppose you can say, is you would like to know the detailed rules of engagement in which the general rule about proportionality is translated into how many civilians are going to be anticipated to be killed in this operation. Now, there's been a lot of criticism of the Obama administration's development of kind of bureaucratic procedures for assessing all of this in relation to drone strikes. It's not really any different from what it was, the U.S. military does anyway with regards to any kinetic operation, because it's required to do so under the laws of war, and a drone strike is no different. The questions that have then arise are ones that were raised, for example, in the presentation yesterday in the breakout groups on drones. What's the basis that you're using to say that this person is targetable? Right? They're actually part of the hostile forces of the enemy. And again, that problem seen from a military standpoint is much less fraught with problems from the sort of general standpoint that the standing general rules of engagement by law for the Defense Department are that hostile forces of the enemy, as reasonably determined by the commander in the field to be hostile forces, may be attacked as a group with lethal force without warning, no obligation to ask them to surrender. It's war. Now that looks very different to an awful lot of people when you're talking about people who are not on a sort of battlefield, they're not wearing uniforms, and the question is, how are you sort of assessing two different problems? One is that you actually are targeting the person who is in fact the terrorist person you're going after, and the second is the person that's in your crosshairs is actually the person that you correctly put on your list in the first place. And it's actually two different identification problems. I'm going to set all those things aside except to say that they raise tremendous problems of sort of legitimacy for the U.S. in terms of its conduct of hostilities in relation to its allies. Virtually none in relation to the U.S. public, to the U.S. Congress, to the lawmakers within the United States. And the Obama administration comes into office promising to end America's wars, knowing that to do that in relation to Al-Qaeda requires that Al-Qaeda be degraded. There may be no terms of sort of surrender, victory, that sort of sense, but degraded to the point of which the risks it poses can be regarded as episodic rather than sort of continuing in a kind of war sense. That's its goal. Now, domestically, under domestic law and with regards to the U.S. population, there's quite a different calculation going on. And that calculation is one that's fundamentally related to a decision made back in the Bush administration, but becomes kind of the defining line for the Obama administration, namely anything that takes place within the United States domestic territory, arrest of people, finding of people, plots, homegrown terrorists, foreign terrorists coming from abroad, will be regarded as fully under the criminal justice system of the United States, period. So anything that takes place within the sovereign territory of the United States will be under the regular criminal justice system. It will not be military, it will not be, so it will be the regular thing, regardless of sort of the source in which it arises. That produces a lot of controversy for U.S. lawmakers, particularly the Christmas Day bomber trying to set his underwear on fire and blow up the plane coming into Detroit, because he's in U.S. territorial soil. And the question is, how's he going to be treated? And special provisions of law apply, leave all that stuff aside, but it turns out to be enormously controversial. The idea that an enemy combatant who is an unprivileged belligerent, who is also a terrorist, who shows up on your soil, you have to treat him under the full panoply of civil liberties and criminal justice protections, even though as you captured him across the border in Canada and Mexico or any other place or in international waters, you wouldn't have to treat him that way. Nonetheless, that was sort of the hard and fast line by which, to a fair extent, the Obama administration resolved the legitimacy questions that arose around the question of you're undermining sort of the Constitution and the domestic civil liberties. Abroad, however, the issue is completely different. In relation to Al-Qaeda, the wars on the ground are actually just a step to get to them. Now, I'm going to leave aside Iraq because it had a different rationale, but you don't go into Afghanistan on the ground because you feel like going into Afghanistan. The only reason you go into Afghanistan is because it's the only way to reach the people you're trying to reach. And you've got to go in on the ground because you have to seize the territory between you and them. Now, the attraction of drones winds up being that you are able to, in effect, to a fair extent, overreach the territory, right? Fly right over it, not have to engage in this stuff on the ground and engage directly with the enemy. And in ways that are indeed vastly, vastly more precise than previous weapon systems by sort of any measure. And one of, I think, the arguments that takes place over the question of legitimacy of drone strikes winds up being around the question of it's not legitimate for X, Y, and Z reasons, but never answering the question that the military will have, which is compared to what? In other words, if the assumption is you shouldn't be taking the strike at all for whatever reason, you shouldn't be engaging the enemy because that's kind of what you're ruling out, well, that's one kind of argument. The other kind of argument is, tell me what kinetic operation you can undertake which is going to produce fewer civilian casualties, which is going to, to a large extent, eliminate the need to fight your way to the position with all of the harms to civilians that winds up entailing. Tell me what the alternative is. And if the alternative is to use a cruise missile to drop a big bomb or to send in special forces operators who may get pinned down, be entitled and authorized to defend themselves, including by engaging in actions that may endanger civilians, all sorts of different reasons. You have to consider what the realistic alternative action is and the opportunity costs that are involved in those things. And drones come out pretty well. As always, whenever somebody comes up with a new air instrument, there winds up being almost always an Air Force officer who will stand up and say, this is the transformative technology. We have finally found a way to achieve victory from the air. Drones are a platform for weapons, and you notice that in the current climate, the sort of furor over drone strikes has really diminished because they're understood increasingly to be just another air platform for striking at the enemy, and that's kind of it. Now, let me move forward then from that to where the Obama administration winds up. It's a laudable goal to try and see how you can achieve peace within your administration. And the administration delivered a whole lot of speeches talking about what that peace would look like. One of the most central and widely ignored points, however, was in the speeches given by its high officials around what peacetime would look like. People tended to ignore the fact that the administration was hewing to the line that has always been the view of the U.S. of international law, and as far as I can tell, the view of every permanent member of the Security Council and pretty much any other country that has a military presence and has anything to worry about beyond its borders, which is that peacetime is actually accompanied by an awful lot of conduct of hostilities operations at a small scale that don't necessarily rise to the legal definition of war or armed conflict, but which the U.S. and other members of the Security Council have always regarded as being susceptible to the conduct of hostilities, and where there is the conduct of hostilities governed by the law of war itself. That's kind of a big sort of change, I guess I'd say, from how many in the community of international lawyers have wanted to see it as being a binary, that you either are engaged in warfare by meeting some certain definition of intensity, duration, amount of fighting, all that kind of stuff, or it's not, and it has to be governed under some different set of rules. The U.S. position stretches back a really long way. In fact, there is virtually nothing in any position taken by the Obama administration on the law of war in relation to non-state actor terrorist groups, which is not actually written out in a speech given by Abraham Sofair when he was legal advisor to the State Department in 1989, in which he said all of this stuff, including under what circumstances is it okay to violate the neutrality of a country in order to go after terrorist groups? The answer, where they're unable or unwilling. And Sofair was articulating a standard that had been articulated in U.S. Sort of views of international law over a very long period of time. So it's much more continuous than people realize, and in that sense, the sort of reach to legitimacy, at least within the U.S. political community, leaving aside sort of the abroad, is vastly more than people actually understand. Now, let me wrap up by talking about where we are today. You may have noticed that peace did not break out. Not even the kind of peace that involves the conduct of lots of hostilities operations, using special operators, using drone strikes, using all that sort of stuff. And part of that was because of the fact that the Obama administration had not done what was necessary in Iraq for that, and I think it sort of was forced to the recognition that Afghanistan. And as far as Al-Qaeda was concerned, the asymmetric enemy pivoted and moved from a strategy of strike from safe havens that are hidden in very small places, maybe a training camp here, safe houses there, but sort of in very small zones to say, okay, what we need now is a sort of new strategy. And regarding it this way as sort of a strategic problem is actually the wrong way to approach it. They always wanted to control territory, but the key thing that not just ISIS represents, but the movements engaged in internal civil wars in Yemen and on into sort of deeper into Africa are characterized by insurgencies that are engaged in battling their own government and would like to seize, as in Mali, swaths of territory and preferably the entire state. Their goal is governance territory, governance geography, over an internal population, over the population and its territory, and then accompanied by either their own external terrorist wing or a very kind invitation to anybody that would like to come and set up shop. And the reasons why this becomes attractive, I think in part, are actually part of the sort of vision of what the future is supposed to look like from a religious standpoint, but also from the standpoint that you feel somewhat better protected in that case. Got it. Okay, now let me point out that that's what gets the Islamic State going. That's sort of the strategic frame. And so the U.S. is discovering that it too is having to pivot its strategy, and the most characteristic part of this is that counterterrorism against non-state actor groups is now entirely intertwined with geopolitics in every respect. Meaning the U.S. for years was in Yemen conducting drone strikes. The Obama administration didn't want to engage that it was involved in yet another war on the ground. But the best legal characterization of what was going on was that the U.S. was acting as the Air Force for the Yemeni government at that point in time in a civil war against the other guys. And that is the pattern which has been sort of set up and has repeated itself or is poised to repeat itself, not just with ISIS. ISIS is not alone in this. It represents a sort of pattern of the attempt to take governance territory and have both the internal and external aspects of this. That shift, combined with the step back of the United States from its traditionally hegemonic role in relation to other state actors, Russia in particular, winds up being the features that are now going to confront not just the Trump administration, but probably several beyond that. And let me sort of end by saying that the problems of the combination of increased instability in state-on-state relationships, the jostling of great powers that didn't exist not so very long ago. Somebody who I won't mention said to me in some panel discussion years ago, but it's a really good thing that we're going to enter a multipolar world in which the U.S. is counterbalanced by all these other stuff. And David Reef was on the panel, turned to her and said, a multipolar world is competitive, not cooperative. Hegemony entails a fair amount of stability. You don't wind up realizing what you've lost until it's gone. And that's essentially the world that we're confronting in both the state-on-state, state-on-non-state, and the use of states by combinations of non-state actors and otherwise. The most important legacy I think that the Obama administration can look for is to bequeath to its successors, and not just the immediate ones, a developing institutional, legitimate, at least within the United States, framework of what counterterrorism is supposed to look like that will be modified as we go in relation to these other kinds of conflicts and changes in the U.S.'s role in the world. And that's actually the most important thing. Peace, nice, but not really attainable for reasons, many of them. But what it can do is that it can bequeath to its successors, and we're working this through in the way that Abe Silfair bequeathed to his successors, a legitimacy playbook, so to speak, that at least within the United States carries legitimacy among its own actors. All right, let me end there. I'm sorry I went on longer than anticipated, and shall I...
Great, thank you.
Donald Trump has talked about the uncertainty factor in a very positive way, that indeed he has criticized the Obama administration for announcing policies at various points and strategies in international confrontations, instead saying that the administration that he will be leading will be unpredictable. And I'm wondering if there is some sort of normalization of unpredictability, or maybe making sense of being unpredictable that could perhaps work well in various conflicts. Again, could you riff off of Trump's remarks in that regard?
I think we'll take a couple of
Sure, yeah.
Sure, these are short. First, do you think that there's any lessening of legitimacy when legal decisions and doctrines are inherited over time? And I'm thinking particularly of the way that ex parte cura really underlay Boudin and the other early Bush administration cases. And then second, do you think that there are asymmetries of legitimacy when alternative sources of legitimacy fuel the conduct of opponents of the United States, and we are continuing to engage in something where we have disputes over the legitimacy of our own actions? So one legal question, one about asymmetries of legitimacy within the eyes of populations.
Yeah, thanks for that rich talk. There's a lot to raise about the legitimacy question, but I want to build on your reflections on the Middle East theater. The Obama administration, in your account, wanted to end the wars. It ended the wars in Iraq and Afghanistan by deciding to lose them, and it tried to end the war with Al-Qaeda by relying on drones. Leave the drone side question aside. Losing Afghanistan and Iraq because of difficulty in maintaining territory. Could we read ISIS really just as an evolutionary response to Obama foreign policy? That is the way to defeat the United States is to hold territory.
Do you want me to?
Why don't you go to these three and then
These three, sorry. On the uncertainty question, I'd actually defer to people with real experience in strategy like Steve on the question of the degree to which the introduction of uncertainty is stabilizing or destabilizing. The general proposition had said that a hegemonic power is interested in a rules-based system that introduces stability. And one way to read the uncertainty is as both an acknowledgement and an accelerant of the idea that you are stepping back from or being forced back from your hegemonic status. But I'm sure that there are ways in which one could read the uncertainty as sort of reinforcing the stability as well. So I wouldn't regard myself as an expert on sort of the I guess, really game theory involved in that. Now, going to the asymmetry and legitimacy within populations, yeah, I think this is a real question, meaning that invaders are not generally seen as being legitimate. And we've attempted to create an international law, cobble together a sort of regime of legitimacy that is the law of occupation for when you wind up going in. It's never worked all that well, right? Because it's intended to protect the security interests of the occupier, but also the population. But it depends on buy-in from the population that occupation is not cooperating with the occupier in ways specified by the Fourth Geneva Convention are not per se illegitimate. Right? And the resistance forces in all those cases under an occupier always say, resist. And as to the legitimacy inherited over time with regards to cases, yes, I see that there can be a lessening of legitimacy, but overall, the sort of much more dominant effect is that, at least in a democratic system with different branches of government, the ability to accumulate over time turns out to be vastly more important to sort of internalized sense of legitimacy, especially with the population. And then finally, to Russ's question about the Middle East, ISIS represents a sort of general understanding by jihadist groups that never really were interested in sharply distinguishing between their opposition to a regime in a particular place as not being Islamist and et cetera, and external operations. Now, the external fighters might or might not, depending, the foreign fighters. But in order to find safe havens in an increasingly hostile world created by the pressure of drones and, but a lot of other things like the ability to sort of restrict travel, lots of economic kind of pressures. There is this desire as a strategic matter to hold territory as a pivoting asymmetrical strategy all by itself. The thing that I qualify that with is it's very easy, I would say, for people in the strategy policy community in Washington and think tanks and the rest to wind up seeing that as sort of, it was just a sort of pivot based on instrumental considerations rather than understanding that in many cases there is this desire to rule the population and the territory that's based in your religious vision of what it's supposed to look like, and that's actually an irreducible part of it as well. But the more general point about that is Syria is the disaster that bleeds out into every other sort of sphere.
Yeah, I wanted to ask you whether, related to the policy of the president of the administration, do they remain similar? I don't mean in a situation of emergency, to the ones in 9/11. I'm curious about how much the president has, or the administration have about power. And then, I don't know whether there are really questions, but some points of discussion or reflection should be restriction of human rights and surveillance. I'm thinking about inside the US, at the same time, there's been also controversy with some of the measures that have affected the sovereignty of other countries. I'm thinking about the allies, some examples. And then to have explained as well the proceeding when it's in an intervention in a foreign country. I think we have started to do that, so we would have different concepts or principles of legitimacy. And then, sorry, because this is not my field, so I understand that from what you have talked to us, so every country now can, I'm thinking about the US and the allies, and these operations can intervene under their own principles. So I don't know whether, of course, we have all the international law, but are we developing some? You talked about the playbook or something, but it was more for the US. Are we developing some at the international level, some framework to add counter-terrorist measures?
So, talking about post hoc justifications that appeal to legitimacy, I guess, at what point does that just turn into winner's justice? Because that was certainly a criticism that was levied against the Tokyo war crimes trials, including by one of the judges.
If I understood you correctly, you've actually pointed to yet another asymmetry, which is the ability to understand, not agree with, but grasp the motivating values of the other side. You could say that ISIS understands our motivating values, and the United States or sectors of the political class and the military class do not, or the public, do not equally understand the motivating values of ISIS. You could have said that possibly about hope as well. And this then leads, it seems to me, that we don't understand that what counts as accumulating legitimacy for them is different what counts as accumulating legitimacy for us. We look at public beheadings and say, how can anyone in their right mind think of that as legitimate? And they see public beheadings as exactly what gains them legitimacy with their target population. And if you fail to not agree with but understand that, you are at an asymmetric disadvantage. The question is, where do we go from here?
Yeah. Well, thank you very much, Ken. And that was really fascinating and lots to take in on legitimacy. And I'm still not clear in my mind. So what's different about fighters now? Because I get the difference with the regular army, but we've also had guerrilla fighters for a long time in the history of warfare. So this category of enemy combatant and the suspension of certain fundamental rights, like effectively fair detention, fair trial, isn't that ultimately undermining claims to legitimacy that we, I think, otherwise rightly make? And is it also part of a recruiting tool for organizations that keep on saying the West talks about, you know, democracy and human rights, but really doesn't practice it, and it doesn't practice it when it comes to very fundamental laws of how to treat, you know, fighters that have been captured. So I still wonder whether the legitimacy argument doesn't actually have to, in the end, mean that we have to lead much, much more by example if we want to preserve and maintain that claim to moral leadership. Otherwise, I think, you know, it does, you know, it looks like a slippery slope.
Yes, let me go back to the first question here, that human rights and surveillance inside the United States and out, and inevitably that winds up encroaching on spying, right, on the other folks. Spying is not illegal under international law. It's not addressed by international law, and the traditional view was you didn't have to worry about legal, illegal, addressed, not addressed, because secrecy made it all go away. If nobody ever found out about it, then there was no discussion about law to be had. One of the asymmetries that the United States in particular faces today is that it's incapable of keeping its spying secret, it's incapable of keeping its covert, supposedly operation secret. It can't keep any secrets anymore, which may be a good thing or a bad thing. But what that means is that it forces onto the table the question of whether it's legal or illegal and what the sort of structure of law ought to be. One thing I think is a risk of the asymmetries involved here is the countries that are willing to, that can't keep secrets or won't keep secrets, wind up being willing to propose some kind of structure of law that is more permissive or less permissive. But then, as with all sort of weapons and tactics and means of conflict, you have parties that would like to enact a public set of rules that are as constraining as possible on the people that will adhere to them, while secretly doing whatever they feel like anyway. And since they're not planning on adhering to the rules, they actually would like to see them as draconian as possible. The one thing that I think will emerge out of this over the long term is that spying is not going to go away. And I think that it's seen by many, many parties as actually being stabilizing rather than destabilizing. Let me leave it at that, however, and agree also that countries have very different frameworks for assessing legitimacy. And that also is not going to go away. And it will depend, in a lot of cases, on just sort of relative power of the country involved. I mean, going to the post hoc justification, when does it turn into just, right? There's no good answer to that, and it's often true in the law. You know, in the United States legal system, we usually characterize it as the can you say it to a judge with a straight face and not start laughing, because we admit the presentation of many legal theories that the lawyer does not necessarily believe will be a winning theory, right? Less than probable that you'll wind up winning with the judge. But it's still a respectable enough theory to be able to put in front, and that's the nature of sort of post hoc justification. Knowing where that lies in its entire context, but within the U.S. system in particular, but it's not just the U.S. system that is suggesting, it's sort of across the board. Everybody does feel this obligation to talk some kind of justificatory language, usually involving law and something that is more than just, you know, sort of brutal necessities of nature, so to speak, in a positive sense. Yes, you correctly described the asymmetry that I'm thinking about. And yeah, I think that it's actually a problem that in the West, generally, the sort of, it's tied to a different conceptions of heroism and, and glory, and religious motivations are not the only ones. And I mean, I often wind up thinking about the sort of language of people like Adam Smith and Ferguson back in the Scottish Enlightenment, talking about the necessary and virtuous retirement of the heroic virtues, that society would be better off if the virtues were those of the honest business person pursuing his interest in good faith, so to speak. The problem is when it comes to external enemies who are willing to fight and die, then suddenly heroism and all those things come back on the table. Specifically with regards to the religious motivation, the one big exception about this is the people, in my experience, that have the best understanding of the importance and power of religious motivation tend to be U.S. soldiers, because many more of them went to church and had religion in their background in a way that the sort of dry, narrow technocrats don't. And then finally, Adrian, going to your point, the U.S. actually has a long legal history of official court cases dealing with irregular fighters, in which the Civil War is the single most prominent of them. And appeal was made to those precedents in almost all the sort of habeas, and the Supreme Court wound up citing those things, but with an important difference, because the question was sort of detention rather than what were the consequences of unlawful belligerency. And the term has been resurrected by the United States, but is now increasingly being used by other countries to sort of describe this category of people who are fighting, and in some sense are governed. You can attack them under the laws of war, meaning first resort to lethal force, not necessarily an obligation to. But they're also criminals, and you can try them criminally, and you're not required to give them POW status. That defines unprivileged belligerency. And so I'd say that at least within the U.S. system, it actually has a long and quite rich history. It's not actually an invention. And other countries, as they wind up holding people, they're going to have to make decisions. For many of the cases, the new thing are people that are on your own soil, homegrown radicalization and all the rest, and the question is whether you have sort of a state of exception regime for them or not. The U.S. has not gone down that road, and I very much doubt will. And that puts a sort of different conception. People captured on the outside, non-Americans captured on the outside are not entitled to constitutional protections beyond a sort of certain minimum habeas corpus right. And in those kinds of cases, the Civil War traditional code for unprivileged belligerency was that you were entitled to shoot them. So in other words, if you fought in a way that carried you outside of the organized armed units recognized as forces of the enemy, irregulars could be, they had to receive a trial, but it was perfectly okay to shoot them, and that execution was the result in a number of cases in the U.S. So there is actually a structure of law. There is just one that people find somewhat uncomfortable.
Well, we're out of time, unfortunately. Thank you very much.